All right, good afternoon, everybody. In accordance with Section 45 and 53 of the Planning Act 1990 as amended, this meeting is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning that applies to property, permission to extend or alter lawful non-conforming uses, consent to sever property to create new lots. Acknowledge land remaining on the traditional territory of many nations, the Chippewa, the Haudenosaunee, the Wendat peoples, and is now home to many diverse First Nation, Inuit, and Métis people. We also acknowledge that the credit. Committee of Adjustment public hearing conducted in a hybrid in-person and virtual format. Some participants will make their submissions in person, others will participate virtually by electronic through WebEx. The meetings are also streamed on the Toronto City Planning YouTube channel, and anyone wishing to view the hearing may watch on YouTube. Participants will automatically be muted on entry. When your item is being called, you will be unmuted by the moderator, one person at a time. We ask that you mute your devices and are called on to speak. Those participating by video appearance will be temporarily upgraded. The is being held. During this time, the camera will be enabled. You will only be visible during your 5-minute allotted. Disabled, and you'll be reinstated as an attendee. For both in-person and virtual participants, staff will share presentations submitted in accordance with the submission deadline. Those participating any other panelist controls during a video appearance. People attending in person today who wish to receive a copy of the decision of the committee fill out the decision request card, and those participating virtually need to submit a written request for a decision by email. Please ensure you use the name, address, and email address. Committee of Adjustment and the Toronto Appeal Body will be sending notifications and appeal updates by email. If you do not agree with the committee, you may, or in some limited circumstances, to the Ontario Land Tribunal. However, the government amended the Planning Act generally removed rights of third parties to receive adjustment decisions. Only applicants, municipal housing affairs, persons, and public bodies, as the terms are defined in the Planning Act, are permitted to appeal decisions to the Committee of Adjustment. I will call each item in the order listed on the agenda. When an application is uncontested, the agent or applicant may proceed with their presentation if desired. When the committee does not require a presentation, we will let you know. Each speaker, including the applicant or any presentation or other materials you wish to submit to the committee must have been emailed in advance. Staff and committee members cannot accept materials at the hearing. When addressing the committee, please clearly state your name and address. Please remember to confine your remarks to the matter. The applicant or agent will proceed first. They'll make their presentation to the committee on the application. Please note, again, to proposals at the hearing today. The committee may decide to defer the application if substantially to ensure that the revised application is accurate and that all entitled to the application are informed of the changes. Then individuals either in we generally call on speakers in the hearing room first and then those on WebEx. Committee members may ask questions of each speaker after speakers are finished. The applicant or agent will have an opportunity to rebut those issues that were raised by the speaker. This will mark the end of the discussion. The application will be taken to the committee for a decision. Treasurer, do we have any deferral requests this afternoon?
We do. It's item number 16, I believe.
Thank you. Actually, before we get to the deferrals, of interest for after session from panel members or staff? I see none. All right.
So it's item number 6.
Yes, item number 16, 115 story detached dwelling by enlarging the rear porch. This application was previously by committee on September 25th. One material from the applicant, letters of objection from 19 Marchwood Drive, 113 Sandringham Drive, corresponding with neighbors and agents. there's, I heard,
We were sent a revised zoning notice, with a variance that was missed by the examiner. There'll be one more variance.
fair enough. All right. And we do, fair enough. Okay. And we do have concern online. Oh, in person. Okay. Well, which one of you guys would like to come down to the podium first? Welcome. And thank you for your patience. There's a button.
Ah.
There we go. I can hear you.
Thank you very much, members of the committee. My name is Bonnie Flatt, and my husband Mike Grossman and I are the registered owners of 19 Marchwood Drive. We share property with property revenue. Now, do you just want me to talk about the deferral?
Yeah, so just for everybody, for a few people that come down, they just have a request for deferral. So, speaking to the deferral request at this time, we're not going to get into the merits of the application. I'm fairly familiar. I would sit on the previous panel back.
Yeah, September.
So, with respect to the deferral request, your submission.
I'm not in favor of the deferral, and the main reason I'm not in favor with the deferral is I don't, speaking on behalf of many of our neighbors, don't trust the owner consultant. We had the deferral in September because we were going to sit down and try to find. We met with the consultant, a number of us. We had back and forth emails. We sent this, which is in the submission I put into the.
Yeah, I'm going to interject. Could you just speak into the mic a little closer? I can hear you, but I just want to make sure Mr. Bankowski can. He's
Okay.
online,
Is
and I want him to respond to what
this
your
better?
concerns are.
Then sent back to Mr. Bankowski our list of requests that would allow us to even withdraw our objections. We were told that the owner was in agreement with it and that we should withdraw our objections. We came back and said, we're happy to do that, provided some actions in good faith so that we can trust you. And so we request for. We're told, by the way, that this was going to be deferred, but we came anyway because we didn't believe that this was going to happen. And so the requests we made were to have 3 things done before the hearing date. Within several hours of sending that email to Mr. Jankowski, came back and said, we are now at impasse. So before, do the restrictive covenant that we're asking for and get it on file, and do something with the lamp. He said we're at an impasse, which to us didn't demonstrate. And so doing another deferral, they're continuing to do work. Bill, they're doing all the stuff. So if we're going to do a deferral, we would really like to have a work stoppage order.
Yes. So I'll just speak briefly to whether or not there is a stop work order on the property. But just hearing your concern, route would be through Toronto Building for a stop work order. There's a building inspector that would be assigned to.
And I've
permit.
spoken to them, been able to get anywhere with him.
Okay. My suggestion then is to escalate to the manager at Toronto Building, let them know that you've reached out to the building inspector, that they provided a response. I would escalate it up. Not, with respect to the stop work order, that's sort of separate. We're really only just dealing with the variance request, or sorry, the deferral request today. So it's sort of kind of we can or cannot do. I will ask Mr. Bankowski as well with respect to the deferral request. I heard that there was a variance that was identified through the zoning commissioner, and something that they they probably weren't aware of. But I have a few questions for himself to that. Maybe we can get some clarification.
Sure.
Whether or not it was done on a waiver or this was through fault. The city, and then like there's always one or two files they've missed something, and I it's up for my members to evaluate the request. It's often hold against an applicant if right. I'll stop there. For my understanding, then you're in favor of the deferral at this. Okay, fair enough. Thank you.
Can I go?
Yeah, but you
Stephen Hoffman in Sandringham, immediately to the south of the outed property. Extension. This is the second request for deferral. The initial deferral, as was mentioned, was really meant for, we opposed it at the first, it was really accepted it on the basis that we should have an opportunity to speak to the consultant and see if we can work things out. As was mentioned, we thought we had, and then at the last moment, we were at an impasse. And so this, to us, just seems like a bit of a cat and mouse deferral game. I recognize that the city came last minute thing, but I would hope you could deal with the one that was deferred and then deal with the other one at a later date. And so for those reasons, we oppose the request.
Thank you. Questions? All right. Thank you.
Thank you.
Okay. Here, speak to this item. Nobody else online. Let's take this back to Mr. Benkowski to respond to neighbors.
Yes, thank you, Mr. Chair. Yes, as you did speak, this was a by the zoning examiner, and he was actually sent to say in for speaking to this. Previously proposed, it is exactly the same. What it is it's an addition of a variance for the form that is being proposed with the roof above it. That's what the variance is being added. And it was an interpretation that it's actually my understanding that the neighbors went city that they're not agreeing to the deferral of the city alteration to the proposal. It was all just again an error in interpretation by the zoning examiner.
Okay.
It would severely prejudice my client to not permit the deferral when we have not changed any part of the proposal.
All right.
The original zoning review. And sorry, one more thing, Mr. Chair.
Yes, of course.
It was not done as a waiver, it was done as a zoning review.
Okay. Thank you for that clarification. Okay, and that email that was sent from I believe it was the examiner you noted, or that's in our
The
package?
examiner sent it to Sam, our caseworker at the committee.
All right, okay. I see staff are confirming that. Okay, let's take this into committee. Members. Yes, Mr. Bartolo.
Yeah, I can get us moving. Well, I appreciate that people and I'm always sympathetic towards that, and I encourage people to come down in person. If the zoning examiner missed something in the zoning or the notice to be recirculated, and you have to get something on paper that may have something else or a different variant, I think it's appropriate to defer the file. Disagreement, I can put forward a motion for deferral.
Yes. No, any other? Okay. Please, Mr. Bartolo.
Yeah, on that basis, I will put forward a motion to defer this application.
Right. Do I have a seconder? Second by Mr. Marziari. All in favor? All right. That's unanimous. The application is deferred. We will hear the matter at a later date with the proper variances circulated to the general public. Okay. Thank you. now to our, no other deferral requests? Okay. You really want the 4 p.m. slot. All right. Okay. Item 13, Drive. The purpose of this application is to alter the existing 2-story detached dwelling by constructing a 1-story front addition to the existing attached garage. This application was previously heard on March 6th and on August 14th at our Committee of Adjustment hearing. Side yard setback, lot coverage, front yard setback, and canopy encroachment into a side yard setback. On file, material from the applicant. I see community planning comments, ravine natural forestry protection, and TRCA. We have our agent with us.
Hi, can you hear me?
Yes, we can hear you. Your name and address, please.
Good afternoon, committee and chair members. My name is JOICEY. I'm acting as the agent and also as the owner of the property.
All right, just give me a moment here. Are there any changes you would like to make to the application?
No, it wasn't really. I apologize for the previous deferrals, but they were more of a personal reason than anything else. So we addressed the sort of planning issues that were sent out already some time ago, and they had already been changed for the last application. So we addressed all of those, and we had conversations with most of the neighbors, and they had basically no input on it, and they were fine with the application. The purpose of the application is to basically make a garage and a half of rather unusable space to turn it into one space for a car that is actually functioning, so you can walk around the car and actually use it as a garage, which is not possible at this point in time, and that's why we need to increase the depth of the garage by the distance, and that obviously then causes a 6-meter setback for the front setback.
Okay. Since the first time this application came before the committee, has there been any changes? Because I do see some staff reports in here, but they're dated a little ways back.
There were some minor changes to the overhangs, and also the side setback was addressed slightly. And I also believe that we shrunk it by, I think, it was at 5.8 or 8.5, I think, and we took it to 6 meters. So there was some adjustment made from the first application to the second one.
Yes, I do see, yeah, the 5.63 meters was increased to 6 meters. And do we have a updated site plan staff can pull up? The most recent site plan? That's, I see, received May 26, 2025. Is that site plan correct?
Let me just increase it a little bit.
Yes, of course.
Which I'm having a hard time with, but let me see here. Can maybe staff increase it a little bit so I can see the setback numbers? Yes, that is the correct latest version of it. That's correct.
Okay, staff had in their initial community planning staff report had initially suggested tying the variances substantially in accordance with the site plan. Are there any concern with that?
No.
Okay. I'm going to ask my colleagues whether or not they would like a full presentation from you, or in the alternative, if they have some specific questions. None?
The purpose of this is single-handedly driven by theft, by the way. It's in order to protect a vehicle from theft, which has happened twice already on this neighborhood and this particular property.
All right. Okay, members, if there are no desire for presentation and no questions, I'm prepared to take this into committee. Okay. All right. It doesn't appear, it looks like we are ready to proceed. If it's all right with you, I can move this right into committee for us.
Sure, that's fine with me. We believe that there's precedence cases that are still of a lesser infraction, so I'm fine with proceeding.
All right, thank you. Let's move this into committee. Yes, Mr. Martiari.
Through you, Mr. Chair, I think it's a supportable application. The applicant made changes based on the staff report back in February. I think it meets the 4 test. I'd like to put forward a motion to approve this application subject to the condition as outlined in the report to tie it to the site plan, the latest site plan, which is May 26, 2025.
Yes, just a point of clarification. The staff report dated back from
February. Yeah. It's
I did see that.
2025. So they recommended to tie it to the site plan.
Just they have a site plan attached to their report. Perhaps we should just tie it to
okay, so let's tie it to that site plan. I think it's more
to the one that the agent indicated. Okay.
I agree.
Yes, please.
Yes, so approve the subject to the condition on staff report dated February 21st, 2025 that tie as attached to that report.
Oh, I'm going to interject. I think there may be an updated plan. The more recent site plan, the applicant can. Happy to jump out of committee just
Can
to
we
confirm.
do that? Can you confirm that?
The
just
last thing I
same?
want to do is
Yes.
tie to the wrong
Yes,
site plan.
yes.
Okay, so let's come out of committee for a minute. Sir, let's just, I really want to confirm that we've got the correct site plan. Staff, can we get the site plan back up on the screen? That's one of them. And then there's another revised in our package. There's May 26th. I think that's the one our agent reviewed. But let's have them confirm. Is he online with us? We have our agent? We might be trying to.
Can you hear me now?
Yes, we can hear you.
Okay, yeah, I followed the conversation. So maybe if you could just zoom in a little bit on the actual garage side, I'll double check the 3 major measurements for the setbacks to make sure that they're the same, and then it should be fine.
Yes, please do.
Yes, I can confirm that this site plan is the one that we would like to work with. That's correct.
All right.
Thank
So
you.
dated May 26, 2025, correct?
Yeah.
All right. That's the one.
Okay.
All right, we got a,
Thank you for checking that.
yes, no, thank you. All right, let's go back into committee.
Just to clarify, that's not the site plan date, that's the receive date. So if you need to clarify that, because the plan date is April.
Yes,
That's correct.
we'll work off the received date, I
Received
think.
date May 26, 2025.
Yeah, okay. Thank you, yeah. Substantially.
Substantially, correct.
Yeah. Okay,
So,
let's go back into committee. Mr. Martiari,
yes.
we're okay.
motion.
Do we need to restate the motion? I think staff. We came out of committee.
Yeah, so again,
Thank you.
motion to approve this application, subject to tying to site plan, receive date May 26, 2025.
Thank you. Do I have a seconder for that motion? Yes, Mr. Vazzelli. All in favor? Substantially in accordance with? Yes. All in favor? That's unanimous. That application is approved. Item 14, 10 RYKERT Crescent. Purpose of the application is to construct a new two-story detached dwelling with a walkout basement, covered rear yard patio, and green roof. This application was previously deferred on October 23rd of the lot coverage height, east and west side main wall height, side yard back way building length, 5 A and transportation. We have an agent with us.
Good afternoon, committee. This is Joel Tanner on behalf of Lindsay Bruce here at Simple Design Studio.
Welcome, Mr. Tanner.
Thank you so much. We are here in front of you with an application for a brand new single-family dwelling, two-story. Happy to put a presentation forth in front of the committee if you'd like. If not, I'm standing by on any questions you might have.
Sure. I just a brief question. Is there any concern if we were to give approval of the application tying substantially in accordance with the site plan?
No problems with that whatsoever.
Okay. We don't have, well, we have nobody here and nobody online. Would we like a presentation from Mr. Tanner? No. Okay. And no questions? All right. Mr. Tanner, can you please direct us to the most recent site plan? I see a revised plan dated November 10th, 2025.
November 10th seems to be correct, yeah.
Okay, I'm going to have staff pull that up on the screen.
Yeah, absolutely.
I think, and third page down. 1, 2, 3.
Perfect.
Mr. Tanner, we have the correct site plan on the screen?
You do, yeah.
All right. All right, this site plan, I see we got a date or a marker that indicate you know, I can let maybe staff decide how they want to title that document, but that is the correct document. I see October 10th, 2025, minor variance R2, I guess revision 2 date on the drawing submission, if we want to use that label. No, sure. Okay, members, any questions? We could, all right, Mr. Tanner, it looks like we can proceed into committee for you, if you don't have any other comment.
I am good, thank you so much.
All right, let's take this into committee. Yes, Mr. Margiari.
Through you, Mr. Chair. A motion to approve this application, and I agree to tie it to the site plan issued date October 10th, 2025. And I can also see in the transportation, so also tie it to those conditions.
Right. Of that application. That's unanimous. That application is approved. Congratulations, sir. Avenue. The purpose of the application is story detached dwelling with a front porch, rear deck, basement walkout. This previously referred on 6/25 variance main wall height, side yard material from the applicant, memo from Urban Forestry, and a previous letter of objection from 45 Clements. With us. Good afternoon, welcome back. Staff, confirming we don't have anybody else online to speak to this item. I don't see anyone on my list. Members, do we require a full presentation? Do we have questions for Mr. Shakiri? None? I have one question, just with respect to whether or not this may benefit from a privacy screen. Mr. Shakiri, have you spoken with the immediate neighbor?
Previously, yes, and they didn't seem to be concerned. Yet, if you feel comfortable to put that forward as a condition, we respectfully accept. I think that's a feature that both neighbors will mutually benefit from it. So I have no objection if you wish to do that. I respectfully accept.
All right, thank you. I believe that that's only going to be on the one side, just given the nature of the deck at the rear. Let's just confirm. I'm looking at the main floor plan. We have a compass. We have to go to the site plan here. Let's just confirm which side that would pertain to. Is it east? On the east side, right, Mr. Shakiri?
Yes, sir. It's going to be on the east side, yes.
Okay. All right. Members, any questions? All right. Mr. Shakiri, it looks like we could take this into committee if there's anything else that if there's not anything else that you'd like to add at this time.
Nothing to add on my side, sir. Thank you.
Okay, thank you. Let's go into committee. Yes?
Through you, Mr. Chair, if there are no comments from the colleagues, I'm okay to forward a motion to approve the application. To me, satisfied the four tests. I know you brought up the privacy screen in the application, but I'm fine with this way, with my motion, so.
Yeah, fair enough. Okay, so motion from Mr. Fazeli to approve without condition. Oh, I'm sorry.
Forestry condition number.
Condition 1. Okay. Mr. Rosier, okay, all in favor? Of course. Third, so we're on to item number 17, 89 POYNTZ Avenue. The purpose of this application is to maintain the existing two-story detached dwelling, two variants before us, building length and lot coverage. Email from community planning. We have our agent with us.
Yes, Andrew Trotter, 81 St.
All right, welcome, Mr. Trotter. Okay. Mr. Trotter, just a clarification. I noticed that in the previous approval, which package, actually, I noticed in your site plan on this package, there's some inconsistencies in what I'm seeing there and what I'm seeing in the built form through the photographs, mainly speaking to the width of the driveway. While I recognize that the variance for driveway width is not before us, I do have a little bit of concern at the fact that the site plan doesn't seem to reflect what is built on the site. Would you be able to provide a bit of clarification as to what's going on there?
You know what, this drawing came up from years ago, and it was just this little thing. Truthfully, I may have just picked up the drawing. Is it possible to just say that the existing to be maintained of the, because I think we went on the driveway with, I think we've been there. Is there any way to just cancel that out or just say existing to be maintained? I mean, this was, oh man, this has been a frustrating little thing, because this has been going on for 8 years. That's on the drawing, sorry, I don't even have the drawing up here, I apologize.
Yeah, no, of course.
And what should the driveway be?
Well, the site plan that's in my package shows 5.5 meters, which is consistent with the previous decision from 2019. But there's some site photos in here that kind of shows the otherwise. Quite a wide driveway that extends all the way from the property line all the way to the other side of the front door. My concern here is that I can't speak for my colleagues, but my concern is that, you know, the application before us is little inconsistent, to be honest.
Okay, well, so you're saying that from the photograph that you see from the thing that it appears to be wider than what is allowed. So if perhaps that happened in the past few years that I had nothing to do with the project and I missed that, and that wasn't conveyed to me in any way that someone had done that. I basically got a call from the homeowner that, you know, the building inspector had come and noticed that the surveyor had written on the lot grading plan a different setback than the survey that he had drawn. And so this was, you know, this was a mistake. I attended to this issue with the setback, and then that 1 foot setback difference increased the FSI by like a very tiny little amount. And this issue with the driveway, I didn't know, I had no idea anything about that. I mean, you've caught that, I mean, that's good. You noticed that. Is this an issue that we could just leave with the building inspector to enforce that the driveway is brought back to the 5.5 meters, if in fact it is wider?
Well, absolutely. I do. I'm trying to, you know, flag it because you may get your approval today, but you may be back here for another variance as built, right? And I'm just trying to be mindful about, you know, certainly the applicant and yourself, time and cost in having to come to committee twice where the application maybe isn't consistent. Again, I'm just kind of picking up my observation. I don't know how other members feel. You know, as I said, there's two variances that are before us. They're not related to the drive. I'm merely picking it up from a you know, reviewing the application for consistency. When I look at an as-built site plan, I would expect that it, you know, more or less conforms, at least substantially, in accordance with what I'm looking on the drawing. But that, to answer your question, we certainly could proceed.
I mean, we're not here, we're here because of the building inspector. That's why we're here. So the building inspector, you know, has flagged this and something else. I didn't even notice myself, truthfully. I had no idea, I didn't notice it. But I mean, he could, say, look, you gotta, remove that, like, whatever that extra is. I mean, we can't determine that from a photograph, we don't know. But whatever that extra, just leave it with them and say, you gotta chop that part of your driveway and make it grass, or you gotta go back in again to committee, and then that's taken care of. I mean,
yeah,
then,
fair
and
enough.
then we end up just closing this, right?
Fair enough, fair enough. Yes, as the applicant or the agent, that is your choice. I'll ask my colleagues, any questions, do we require a presentation from Mr. Trotter? Okay. All right, if it's all right with you, I can take this matter into committee and see what my colleagues have to say. Okay, let's move into committee now. Mr. Bartolo.
Thank you, Mr. Chair. I mean, despite the issues with the driveway, and I think the photographs are, as you say, that it's larger than what's on the plans. The other two items that are in front of us here, I don't see them as being particularly onerous. The city staff have no issues with them. I think they meet the 4 tests. They're minor, and I'm prepared to support them.
All right. Do I have a seconder for that? Mr. Fazeli. All in favor? Okay. All right. And Mr. Allison will be opposed on that. That motion carries. The application is approved. Congratulations, sir. Hopefully we can, of course, hopefully we can get you on your way. Okay, moving right along here. We're on item number 18, 177 JOICEY Boulevard. Purpose of the application is to build a new detached house with a built-in garage. Variances include main wall height, first floor height, number of stories, building length, east side yard setback, west side yard setback, lot coverage, and area for a second-story balcony. On file, material from the applicant, memo from Urban Forestry, and a letter of objection from the South Armor Heights Residents Association. We have our agent with us.
Hello?
Hello.
It's supposed to be the owner. I don't know if she's there. Megali, are you
there? Before we get going, sir, your name and address for the record, please.
My name is Jerry Parushkevich. My address is 58 Elm Avenue, Toronto.
Through you, Mr. Chair, what I'm hearing is that the agent is expecting the owner to speak.
Sure. Just a point of clarification, as the agent or the owner, either of you can speak. Just be mindful that we got 5 minutes allotted to both of you guys. So however you want to split that up, that's your prerogative.
Yeah, so the stakeholder is not picking up. So that's okay. Shall I go through all the variances?
Yes, please. Yeah, we do have some opposition to the application, so I would like a brief presentation from you.
Okay, so 8 variances. The first one is regarding the height. The height is 8.97 meters, where permitted is 10 meters. So the height is just coming from the fact that the building is with flat roof, and the height limit for the flat roof is 7.5 meters. If we redesign the house, which has part of the roof sloped, the house will have still the same volume from the street and overall. But we prefer just clean, modern design as proposed. The second variance is the first floor height, which is 1.92 meters, while permitted is 1.2 meter. It's quite common in the neighborhood. It's just coming from the fact that the garage is on the ground. The third variance is regarding the 3-story instead of 2-story. This is coming from the fact that our basement is not, we could have lowered basement by approximately 1.4 meters, then this variance will disappear. And it looks like nobody objected it from the neighbors. The fourth variance is regarding the length is slightly longer than permitted. Permitted is 17 meters. We have 17.38 meters. So it's quite minor. Even the neighbor's house at 179, JOICEY, is a bit longer. The fifth and sixth variance is regarding the setbacks. Setbacks is on the west side, 47 centimeters. Existing house is actually much closer, 35 centimeters. And on the east side is proposed 58 centimeters. Those setbacks are, you can see in the neighborhood that they are quite common because the ones are not that big. The seventh variance is regarding the coverage, which is 42.4 or 25. Somebody made different calculations. Actually, this comes also from the fact that it is calculated. The calculations includes the pool cabana and front porch. And if we exclude this from the calculations, our coverage would be 38.38%, which is quite minor variance. And the last variance, number 8, is second-story platform area. This platform is, the variance actually comes also from the fact that we have 3-story building technically, and this platform or balcony is by law on the second floor, while it is really on our main floor, I would say on the first floor. So that's about just, there are also some complaints, mostly regarding there's objection from number 16 DUNBLAINE, which is the house just at the back of the owner's property. And there's one thing she's writing about pool cabana, that it is just 1 foot from the property line, while it is actually proposed 18 inches from the property line. She was also complaining, I think, about balcony. I must say that her property is in ours, which will make the impact of the balcony slightly lesser. And there is also comment from the forestry department. I sent a couple of days ago suggestion to revise the site plan, which will avoid when we can move slightly this walkout basement, pool, and cabana to avoid tree protection zones. So this is just figure which will not cause additional variances, but we can solve this problem later on when we talk to the forestry department. For now, I would keep the project as it is.
All right, thank you. Questions? All right, we have some other speakers. Let's get them online. Hello. Okay, I think I heard somebody. Oh, all right.
Through you, Mr. Chair, Danny Mitonidis is unmuted.
Hello.
Danny, you are unmuted if you can hear us.
Hello.
Hello, hi. Do you hear me?
Yes, we do. Your name and address, please.
Yes. Sorry about that. I am the owner of 177 JOICEY Street. I was not able to join before.
Yes, your agent just spoke for you.
Yes, but I wanted, in fact, I wanted to provide some context of
Oh, okay. Your agent just spoke for you. He hasn't used his full 5 minutes. I'm very brief. If you provide a few comments, because we've just heard from your agent.
Through you, Mr. Chair, you want me to unmute here again?
Yes, please.
Okay.
Yeah.
So yes, well, you want me to be very brief, or you don't want me to?
No, your agent's spoken at the onset of this. Sorry, let me just clarify. At the onset of starting this file, I noted that because there's two individuals, owner and agent, you guys can decide how you want to split up the time. But you've only got 5 minutes, and now your agent just spoke. He hasn't used up the full 5 minutes, so I'll provide you an opportunity to speak, but just be mindful that you won't have the full 5 minutes, okay?
No worries. Okay, you say the receipt. I just wanted to tell you that it's a very important project for us. When we designed the house, something very important for us was the ability for our parents, aging parents, to be able to access to the house. And that's why a big portion of the design and the work we did with Jerry, our agent, was related to the accessibility of wheelchair person.
Okay, thank you. Thank you for that submission. Any questions right now? Okay, we're going to come back to you, but in the meantime, I would like to hear, there's some people here to speak to this that have some concerns. All right, staff.
Hello?
Hello.
Hi. I'm Nancy Basso. I'm at 16 DUNBLAINE. I'm the property in the backyard of
Yes.
the property going up. I know you've received my objection, well, my letter. It's not completely objection. I've come to committee many times, so thank you for listening to my concerns. Over the last 20 years with the Committee of Adjustments, I've come on my own behalf for a whopping 100 square feet. I'm finding some of these, side setback, length of property, now it's considered 3 stories, okay, fine. The lot coverage seems excessive. I don't believe that the calculations, if you look at A01, I don't believe the calculations includes the pool equipment, which would make it to 43. The notice of public hearing says that it's 42.4, the drawing shows 42.25, so there is some inconsistency here on what is the lot coverage. But I don't think it includes the pool equipment, which looks like from the drawings that it has a roof, it has a door, so it should be part of the ancillary space in calculating the hard surface area. What I've noticed also from the drawings is, they went to the maximum on the hard surface areas and basically to the bare essential bylaw on the green space. So that's the way they've covered all their hard space. So they're also asking for more lot coverage. Even the South Armored Heights objection letter stated that when you're looking at close to 4 times the value of the bylaw, it doesn't seem like a minor adjustment anymore. It's really a major adjustment. So I think most of my neighbors have small balconies off their kitchen. I'm sure they would have loved bigger balconies, but they were not allowed based on the bylaw. So this one seems a bit excessive. If it could be taken down, not taken completely down, but shortened, made it smaller, that would be great. So, and then I did have a concern about the cabana butting up against the fence. It's only a foot. We have Bruno's, which is 5 doors west of this property. we have rats and mice issues in the neighborhood. Everybody has pest control out here. If you can't get around a building, you can't see if they've dug a hole to make their little homes. So it would be nice if they do something pest control, or they move the cabana a little further off the fence line so they can get around the building. Those are my concerns.
All right. Thank you. All right, questions? All right. None? All right, staff, we've other speakers?
Through you, Mr. Chair, I tried to call Danny Mitonidis. He's having an issue with his microphone, so I'm going to call him and put him on speaker.
All right, thank you.
Hello?
Yes, I will put you on speaker so you can speak to the committee members, okay?
Thank you very much.
Okay, go ahead.
Yes, just to reiterate, I listened to the agent speak about all the variances, and there's quite a few. Very aggressive in certain things that are not in the neighborhood at all right now. But first of all, I think he made mention that he had talked to the neighbors, and the neighbors don't have problems with any of these variances, or at least the 3-story height. I don't know about the other neighbors. I'm pretty much right across the street from at 176 JOICEY. At no time did anybody contact me or ask me for my input on any of this information. So I just want to clarify that that was an incorrect statement, at least on my part, with any contact. Starting off with the most egregious change in the neighborhood is putting 3 stories on a property where on all of JOICEY Boulevard and any of the surrounding streets, there are no 3 stories. So this would be a big departure of the aesthetics of the neighborhood. Everything in the neighborhood is single-family homes or bungalows, and this would wreck the existing look and feel. And they just bring in more denser and taller buildings in the future. Once you permit that on one building, and then everybody else that's going to tear down is going to want a 3 or 4 or 5 story. And this is a residential neighborhood, and there's nothing taller than a 2-story. While I can appreciate the reason the person wants 3 stories, I mean, everybody wants more square footage. We would any builder wants to put as many stories as possible so they can sell it for more, but that's not the concern of the neighborhood. The concern of the neighborhood is to keep things in consistent feel and look. With the issue with pool cabana and backyard changes, I don't think there are any pool cabanas in the neighborhood. I don't know how that's going to disrupt the other neighbors around, but certainly people have pools, but nobody has other structures in the back. I oppose that as well. In terms of the ceiling heights, I think the person mentioned, well, we can't go as far down in the basement as we'd like. Well, nobody else can go as far down in the basement as they like. That's the whole point. So my strong objections are the 3-story height, limiting it to 2 stories, the pool cabana, and in terms of the backyard porch, everybody, in terms of the adjustments with the committee over the years in this neighborhood, has been restricted in their terms of their size, their backyard porch. I don't see why that should be allowed for this person building, that they should have much bigger or wider or longer porches than anybody else that was allowed. So those are my objections. Thank you very much.
Okay, thank you for that submission. Questions? Okay, thanks. Mr. Schwartz, yes.
Yeah, I mean, I noticed the Ratepayers Association said that variance number 3, they don't object, right? They say that with a basement with 2 floors above it, it's a technical 3-story, right?
Yeah.
Is that,
Yeah, that might be more of a point of clarification that the agent can make about why it's considered a 3 versus a 2.
But didn't this resident just said something on that?
Yeah, sorry, maybe I don't understand your question.
No, where are we? Is the resident still online?
Yeah, do we ever?
Mr. Chair?
Yes.
We really need the the members to speak into the microphone, please.
Is the resident still there?
Yes. Yes, let's get our resident back. I think Mr. Schwartz has a question.
I was just going to ask him how he reconciles his view with that of the ratepayers. That's all.
Sure.
Yes.
So, like you, I would typically be concerned about a 3-story, but the
Sorry, you're breaking up.
Can you hear me?
I can hear you now.
Okay, I'll try my best to speak into the mic. So, I heard your comment about the 3rd story.
I'm sorry, you're breaking up. I can't make out. I mean, if I turn on the audio of the computer, I don't know if it's going to interfere. I'll probably be able to hear you better, but I can't hear but a word or two of your commentary.
You know what? It's okay. I don't have any questions. Let's just go.
Yes, I think there's we'll get some clarification. I think we'll get to,
we got technical.
I think I know where you're going with it, Mr. Schwartz. We'll get some clarification from the agent on it.
So let's forget the question.
Okay.
Let's keep
Staff, do we have any other speakers? Yes, we do. Sorry, Mr.
Let me unmute him.
Can you hear me?
Yes, we can hear you. Name and address, please.
My name is Untitled, O-P-U-N-C, last name is U-N-A-L. Address is 45 Glengarry Avenue.
All right. And your submission, sir?
What I would like to mention is I'm Magali's partner, and just to give a bit of clarity, we actually met with both directly adjacent neighbors and seek their alignment and listen to their feedback. We are seeking a number of variances, but if we are able to show the section through the house, it's actually a basement plus the main level and then the bedroom level over top of the main level. As I understand, the bylaws are such that the closest floor to the established grade becomes the main level, and due to that, our basement is considered main, and this has compounding effects. And one of them is really that the house is considered 3 stories, but it also affects the rear view, whereas it's really going from the main out to a balcony, and it's not a 2nd level balcony from the bedrooms looking into neighbors' backyards. And to our directly adjacent rear yard neighbor, we're sorry that we haven't connected with you earlier. We do notice that your adjacent neighbor actually has a very massive porch, or I'd say balcony or terrace. And I do understand how you would be confronted of something similar very close, but we are quite far. And our lot is about 1 to 2 feet lower than her lot, so I think it won't really have a big impact. But yes, if we can go to that section, I think that really says a lot. If we go to, is it A7? This one clearly shows that there is a basement, a main level, and then bedrooms. But really, due to this technicality, I believe we have a number of bylaw infractions, whereas we're not trying to build a massive house. And as we showed these drawings to our directly adjacent neighbors, they also thought that they only got a site plan and notice, and then once they saw the drawings, they said it's actually a lot smaller than what we thought it was based on the notice. So I just wanted to highlight this, and that's really it. That's the end of my comments. I think our agent explained some of the other things, but we have alignment with our directly adjacent neighbors, and respectfully, we'd like to submit our application for your consideration. Thank you.
All right, questions? Okay, do we have any other speakers? Okay, we can go back to our agent. Yes. Okay. Just a point of clarification to our agent, whoever's going to speak next. if we can just maybe keep it to one speaker for a response, because I realize we have the owner and the agent.
Yes, I think Vince just explained the three-story situation, and I just want to assure the neighbor from Dunblaine that full cabana was included in calculations for the coverage. So if we don't count this. Full cabana will have around 38%, not 42. And front porch, sorry.
Okay, thank you.
So I think that the rest is probably quite clear from the previous speaker.
All right, thank you. Questions? Okay, staff, just a note, Mr. Vizzelli's stepping out, so we're down to 4 on committee, just so we're aware. Okay, let's take this into committee now for a brief discussion, followed by motion. Mr. Schwartz.
So I looked carefully at the letter from the Residents Association. And they were okay with the 3 stories. So I think that they've made it clear. So that I don't think is a big problem.
Yeah.
But they had a problem with 5 of the other variances. They say that they are substantially beyond the zoning bylaw limits and not minor. And because I think there's just too much here. It's not just the 3 stories. There's the RD zone limits, which seem to be excessive. So I don't believe it would meet the 4 tests under the, in terms of zoning. The scale proportionate compared to other neighboring homes, and I don't consider this to be minor in nature. So.
Yes, Mr. Marziari.
Thank you, Mr. Chair. I agree with Mr. Schwartz. I think I don't even 3-story. The basement is almost at the grade. With the height variance, combination of height variance and also entrance elevation, it is 3-story. So it's creating another variance, which is variance number 8. At the number 6, which is about setback, I think the building is pushed on both sides, too close to the property line. I don't know how the backyard can be maintained this way. So it's not supportable application for me as well.
Yeah, Mr. Bartolo. The big flag for me was the massive terrace off the rear. It's just way too high up in the air. Generally, in terms of depth and length, I think somewhat supportable. But to your point, Mr. Marziari, about the side yard setbacks it really is kind of pushing where it can, and it's. I guess it depends. For us, we got to figure out where it becomes too much. For me, as I said, yeah, the issue was the platform at the rear, but I do accept your comments with respect to the other variances. Perhaps a motion from either Schwartz or Mr. Marziari.
I'm going to bring a motion to refuse.
Okay, Mr. Schwartz brings. All right, the application is refused. Are we okay to continue, members? Okay. Mr. Schwartz, are we okay to keep going? Okay. If at any point staff or members, we need a relief break, please let me know. I'm going to try to push us through to the end. We're on item number 19, 34. Purpose of the application is to construct an addition over the existing attached garage in conjunction with other interior and exterior dwelling. 6 variances before us: building length, building depth, rear yard setback, front yard soft landscaping, side yard landscaping, and parking space width. On file, material from the applicant, correspondence with transportation, and 1143 and 144 Rochester Avenue. Okay, do we have our agent with us?
Yes, I do, Chairman.
Welcome. Okay. All right, we have some opposition, sir. I'm going to ask for a presentation from you when you're ready.
Yes, my, Mr. Chair, my name is RYKERT, and I'm an architect from RYKERT Architect. I'm agent for this application. My address is 1100 Shepherd Avenue East, Unit 309, Toronto, Ontario.
All right, whenever you're ready.
So the purpose of this application is to construct a second-story addition on top of the existing garage. But at the same time, we are expanding the existing garage towards the north and west of the property. And we have received 6 variances to do with this proposal. Many of those variances to do with the orientation of this building, because this building was originally constructed in accordance with the old zoning bylaw in North York. The shorter lot line was considered the front lot line. So the zoning examiner has reviewed this application in accordance with the originally issued building permit, and they have taken the Rochester Avenue as the front lot line, which the building originally is set way back from the front lot line, and it's the main reason why the building depth is that much high. And we have a rear yard setback of 2.8 meters proposed, while the existing rear yard setback used to be 3.07 meters. So these are the variances to do with the placement of the original building in the existing lot. The other variances to do with the soft landscaping. I have to say that we are not changing anything on the landscaping. We are just making those changes to the garage area and the second story.
All right. Questions? Yes, Mr. Bartolo.
Yes, thank you, Mr. Chair, through you. To the applicant, based on the 6 variances we have in front of us, how many of those are existing conditions if you didn't expand the house at all, if you did 0 modifications to it?
If we didn't expand the building, I think the number 4, south yard landscaping, number 5, again, side south yard landscaping. These are 2 variances to do with this, if we didn't change anything on the application.
No, I'm not saying if you didn't change anything on the application. If you didn't do this addition or expansion. Yeah. Okay. So when I read the plans, and I'm referring to A01, you're going to demolish the existing garage, and then you're going to expand the footprint of that garage.
That's right.
I'm trying to determine exactly how much you're expanding it by. I can't see all of the old dimensions on here.
So if you go to A1-2, we are expanding the garage by 2 feet and 11 inches to the north, and 2 feet 5 inches to the west.
Okay. So, I'm just going back to the public notice. Even without that expansion, your building length and depth would certainly be over what's permitted in the bylaws.
Yeah, I explained to you, the reason why it's that is because the Rochester Road has taken as the front lot line. If the Mildenhall Road was taken as front lot line, the variances would be totally different. And we wouldn't have any building length or building depth variances, but we did have other variances like maybe front yard setback or rear yard setback. We had definitely those variances. But this is the interpretation of the zoning examiner that has taken the Rochester Avenue as the front lot line.
And your house is pretty much set back at the almost the fully to the rear of that property line then?
That's right.
Okay, I'm understanding a bit better. I think those are all my questions for now.
All right, thank you. Okay, we have another speaker. Yes.
Hello?
Hello.
Good afternoon, members of the committee. I'm Sarah Baxendale from 144 Rochester Avenue. We share a direct property line with 34 Mildenhall Road at that back corner. So I wanted to start by reminding the committee that this same property appeared before you less than a month ago on October 23rd. That application was deferred because both the survey and the plans were inaccurate. Despite that deferral, the applicant has now submitted a new application. This one seems to treat that previously deferred variance, which seems to still be online in the committee portal, as if it were already approved, and then it adds an additional 6 new variances. This new application was actually submitted before that October 23rd meeting took place, which demonstrates that the applicant did not actually intend to wait for your decision and plan to expand their request regardless of the committee's decision. And I think procedurally this is inappropriate and kind of undermines the public review process. From my review, the information before you is still inaccurate. The survey, if you go to that, amidst major structures that exist on the property now, including a large concrete deck, a large enclosed pergola, a concrete deck with a second lower level extension, and hardscaping that connects to that deck. All of this construction was done without city approval, and in fact, from what I can see online, the owners already received a zoning bylaw notice violation for that unapproved deck extension and pergola, as well as the lack of soft landscaping from a pickleball court addition that was added earlier this year. Some of these structures are still being excluded from the survey, which misrepresents the true site conditions as well as the extent of non-compliance. And with incomplete and accurate information, it's hard for both the committee and neighbors to properly evaluate these variances. The plans also continue to mislabel hard surfaces as soft landscaping. If you go to page A6-1, it lists concrete, gravel that have wrapped the house in full, a retaining wall, and a path to the elevated decks, which would have no other way to access it as soft landscaping. So unless the applicant is planning to remove all of these newly built structures, their landscaping numbers are very overstated and inaccurate. The applicant continues to treat unapproved construction as existing. They present the deck, the pergola, the retaining walls, and the pickleball court, and all the excessive hardscaping as baseline conditions, stating that had they not applied for this addition, they would not have any impact to soft landscaping, and that is incorrect, and they're using that to justify, additional variances. The applicant claims that they face hardship because of those existing site conditions. Either if the property line was read off of Rochester or off of Mildenhall, they would still have several variances due to the soft landscaping and changes being added here. They built the oversized pickleball court, those large retaining walls, and concrete deck without approvals. These additions reduce their soft landscaping and usable yard area significantly, and they're now requesting even more overage for this new addition on the driveway portion. And then more importantly, their first zoning submission for this addition, the one we're listed here, was filed in April of 2024. before they built any of those additional backyard structures, pergola, the entire deck condition. This shows that they had planned the sequence in advance, to my understanding, and are now asking the community to both legalize and show even more leniency for this addition. Just putting aside quickly the procedural and factual problems, the permitted building depth is 19 meters, they're proposing 37 meters here, and the required rear yard setback is 11.4, which is the one that borders my property, and they're proposing only 2.1 meters there. These are not minor variances, they nearly double the permitted building depth and virtually eliminate all rear yard open space. This contradicts the intent of the zoning bylaw, which is meant to preserve soft landscaping, protect character, and prevent stormwater runoff. As a direct neighbor, the additional hardscaping installed this year has already worsened the drainage and runoff on our street, and I would have appreciated to have had some of these changes discussed with a member of our household prior to any of these changes being done. So quickly, in summary, the application, to my knowledge, is based on inaccurate or incomplete information. It attempts to legitimize unapproved construction that has already triggered a bylaw notice violation while adding even more. The hardship that is being claimed seems to be self-created, at least some of the variances listed here, and the variances are major, not minor, in terms of how the impacts on the stormwater, drainage, and quantity inside of construction. Thank you for your time.
All right, thank you. Questions? All right, let's turn it back to our agent. Provide him an opportunity to address concerns that were raised by the immediate neighbor.
Yeah, I have 2 points to mention here. First of all, I am not the same applicant as the previous application to do with this property. That's another application with different applicant. I have nothing to do with that. The second point is that the existing wood deck and camera that which is mentioned on the presentation are legal, and they have building permit application numbers. I have mentioned those application numbers on the site plan. You can refer to those. Building permit numbers, which are 24169281, building 00SR, and 25178841, building 00SR. These structure has been approved by the city. They have building permit, and they are deemed existing. So, I mean, the purpose of this application has nothing to do with landscaping. It's only about the existing garage, expansion of the existing garage, and additional second story on top of the existing garage.
Okay, thank you. Sir, a little confused. You just said that the application doesn't have anything to do with landscaping, but there's 2 variances for landscaping here. Is my understanding that as part of the application, I understand that there's a proposed addition at the rear, an intensification where the garage is to extend the house further back, but I also understand that there's another part of this application which is to legalize something that's already existing in the front yard, which requires variance number 4 and 5. Could you just provide a little bit of clarification there?
So there is no projection of the existing wall. I mean, projection of the garage to the front lot line. So we're just expanding it towards the north and west. So none of those variances to do with landscaping is related to the proposal of the second story additional expansion of the garage. So that's the question Mr. Bartolo asked me first regarding the variances. He asked me if there was no changes to the existing building condition, which variances would you get? I told that variances regarding the landscaping, which has nothing to do with the this application. If I submitted this application as is, I mean submitted the survey plan to the zoning examiner as is, and I didn't ask for any proposal, those 2 variances would list in the notice.
Okay, so do you want to remove variance number 4 and 5 from the application then?
So we are not changing anything on the front yard landscaping, nothing.
Can I ask a question in another way?
Yeah.
So the pickleball, has it been done through a permit, or it's just done? Because it wasn't like when we look at the Google map, it's not there. So it's created to us, it's built without zoning review and permit, and it's creating now a big soft landscaping variance, which is a part of your application. We understand that you're not proposing any change to that, since it happened like, I don't know, 1 year ago, 2 years ago, but it's there. And it's creating a soft yard landscaping variance, which is big. Can you clarify that?
That's right, Mr. Manager. I think that's the source of the problem, which is the subject of another application. The other application was before the committee in October 23rd and was deferred. It's to do with this country pad, which is excessive and built without permit and without zoning review. So I believe that this has nothing to do with this application. It should be referred to the previous application.
The variance is there. The variance is already pointed as a variance. It's already included. That application has not been resolved. So you're coming with the new application, and it's already including that variance. So
yeah, I was not aware of that application at all. So it was asked separately, and I was not aware of that. But maybe we need to coordinate these two applications, and we submit this application as one application. If you have any question to do with this variance.
All right. I mean, I don't know, colleagues. This seems like this is an app. The application that's before us is inclusive of the legalization of an existing deficiency in the front yard, but it also includes a portion at the back. If the agent is stating that this pickleball court in the front yard is not part of the application, then why are there two variances there? And then what would be the objection if we either removed or refused those two variances if they don't affect the application that you're putting forth?
Yes, we can remove those two variances, and it can be dealt with in other applications.
All right. Do we have any other questions at this time? Okay. Let's take this into committee.
Yeah, Mr. Chair, it's a bit of a confusing application because it looks like it's trying to legalize the pickleball court is driving the landscape issue.
It is,
right?
100%.
There's no doubt in my mind about
No
that.
doubt.
In principle, demolishing the old garage and adding 2'11" and 2'5" to it, I don't think is crazy. I'm going to make a big.
No, I think it's actually it's good actually, and I sorry to interrupt. I will provide a little bit of a planning justification for that building length, just given the nature of the lot and the way that the existing structure is intended to sit on it. I don't think it was ever intended to sit at the front of the lot. It's a corner lot. It was intended to sit at the back, and I think that the agent is. It's interesting because I think this is a really good case of where the bylaw and the actual site conditions, they just unfortunately they're not one and the same. They're very different. I think the addition at the rear is pretty supportable. The variances are really just a result again of the fact that the front yard technically is a front yard, but is kind of also their rear yard. It's really their rear yard, right? It's reversed, but the way the bylaw treats it, because of the lot orientation, they treat it differently, right? So you have these crazy variances for length and all that.
That's right. I think we can
Yeah.
see past that.
We can see past that.
And the setbacks, I get, they're not an issue. The parking stall width is not an issue for me. The landscaping doesn't make any sense.
Yeah.
It's off.
Well,
it's capturing other.
I was willing to give a little leniency on the landscaping. The requirement is 75. They've got about 50, just over 50, right? But to my point earlier, the requirement for 75 is for a front yard. My understanding is in a rear yard it would be 50, and I'd be willing to treat this as a rear yard. If we did, they would be in compliance if it was treated as a rear yard, which yard really is the rear yard. But I'm really kind of bothered by the submission made that this landscaping and this pickleball court has nothing to do with the application, when that seems to be far from the reality of what's before us. There's two variances for landscaping, and they directly relate to an as-built condition. Where I was confident, I'm not so much now. But that might also come from the agent's just misunderstanding or. Yeah, the drawings are difficult. Yeah, I'm getting a little confused with the concrete, what's wood. There's separate permits for that. It's just not clear to me. This is a case where my hesitation is based on the fact that the applicant hasn't done a fair job of clear the application that they're putting forth. I don't know, Mr. Schwartz, you got a comment?
I don't support this application.
Okay.
And I'm still concerned, I heard so much confusion about what's a pickleball court and is this soft landscaping. You have a resident saying that they brought application, now they're tacking this on. But even if you strip away all the confusion, and the confusion enough would be a good reason to refuse it. You have major major variances here, right? 1, 3 are major. Past that perhaps, but I'm not willing to look past it when there's all this other confusion. It needs to be really well documented, I think, to us clearly why the extreme variances in terms of length, depth, rear yard, those are contrary to the neighborhood policies for the official plans. Would be also RD limits and zoning, and I think it's hard to say they're desirable for development, and they're not minor in nature. So they don't meet any of the 4 tests in my view. So if you want to come here and say, well, yeah, there's good reason why we don't meet any of that, but then there's all this other confusion on top of it. So I just can't support this.
Please.
Yeah, I understand what Mr. Schwartz is saying. I understand the confusion around the package here. I don't think there's any problem with it. To be honest, I think I could support everything except for variance number 4 right now.
Mr. Marjari, please.
I agree with Mr. Bartola, and also I think you, Mr. Chair, looked at it in an interesting way, because I agree with you that the front yard, if you consider the backyard, the 50% landscaping can be supportable.
Yeah.
But to us, done it in a more graphical way to to explain that this is the front yard, this is the backyard, and that this property is flipped. So,
Flipped, yeah.
To me, I think if I could see that, I could support that. But without that, I cannot support variance number 4. But the other variances, to me, it's supportable. I don't have any problem with the addition.
Okay. Maybe a motion, see where.
My motion and his motion are going to be different. My motion would be refused. So you're going to refuse that, so you may as well make your motion. But my motion is refused.
Motion to refuse the application. Do I have a seconder? All right, motion fails. Do I have?
Mr. Chair, I will put forward a motion to approve this application with the exception of variance 4, which I refuse. And
do we need to tie to site plan?
I don't
given
know if
the
you
numbers
can
here?
tie it to the site plan if you think there's violations
Substantially.
of the site plan.
Oh, I mean the at least the variances.
You know what? I will accept that.
My
friendly
concern is
amendment.
you offer a
Yeah,
length of.
Yeah, you're
you
right.
can imagine what they could build.
So I'll put forward a motion to approve this application with the exception of variance number 4, subject to the following conditions: that all approved elements be substantially in accordance with the site plan attached.
All right, I have a second. Okay, opposed, Mr. Schwartz. Okay, the motion is for approval. Part is approved with condition. Okay. Mr. Bartolo's. We've got 4 items left. Gentlemen, you think we can push through? All right. Staff, we're okay for relief breaks? All right. Item number 20. You can see I'm losing a little steam here myself. 23 Bannatyne Drive. The purpose of the application is to construct a new 2-story detached dwelling with a walkout basement and a variances include east side yard setback, side main wall height, and lot coverage. On file, material from the applicant as well as memo from registry. Yes, we can hear you. Name and address, please.
My name is Ali Reza Bakri, and my address is 150 Dunblane Road.
All right. I'll ask my colleagues whether they require full presentation. I'll just, in the interest of time, I'll just put it out there. I would like to hear a little bit of submission with respect to the lot coverage at 35%, where 30% is permitted. If there's some planning rationale there. I'll ask my colleagues, before we get to that though, ask them if they would like a full presentation. No. All right. Actually, yeah, if you could provide a little bit of rationale, I think they go hand in hand, but I'd just like to understand a little bit about the request for the 35% lot coverage, as well as the reason for the the reduction on the east side yard setback from 1.8 to 1.2. All right.
Start my presentation?
Yes, please.
Actually, I should say that we have worked to ensure that these variances fall within the established physical character of this neighborhood, and the existing east side yard setback is 1.2 right now, and then we decided to keep that. The lot coverage is very common in that area, in the 33 to 35% range is very common in the area, especially at that block. And I should say that the committee has approved for new homes in that area. We have some approvals for that lot coverage in the area. And the proposed east side yard setback is also the same as the existing side setback on the property, maintaining the current spatial relationship with remaining consistent with similar approvals in the area. It preserves appropriate building separation, and I believe that continues the rhythm of the spacing along the street and does not introduce any concern related to shadowing or overlay. The other reason is that if you see the architectural drawings, we don't have a deck at this house. We have a small platform that provides access from the main level to the backyard and with 3 steps. Then it prevents any kind of overlook or privacy issues to the adjacent neighbors. Yeah, this is the reason that we asked for the 35%, and I should say that this is the house for my client for kind of family of 4 with their parents. This is the reason they wanted to extend their house to 35% to provide more living space in their house.
All right. Thank you. Thank you for that. Questions? None. All right. I'm satisfied. If it's all right with you, I can move this into committee now. Yes. Let's take this into committee. Mr. Maggiari.
Thank you, Mr. Chair. I think it's a supportable application. They're seeking 3 variances. That, to me, it meets the 4th test of the Planning Act. So I'd like to put forward a motion to approve this application subject to urban forestry condition number 1.
All right. Mr. Schwartz, will you second that? Yes.
Approve with urban forestry condition number 1.
All right. And Mr. Schwartz second that, so that automatically gets the approval. I'll also be on record as support. So that's unanimous. That application is approved. Item,
Thank you so much.
Of course. Item 2198 Dunblaine Avenue. The purpose of the application is to construct a rear yard deck to the detached dwelling being constructed. 4 variances are before us: side yard setback, platform area, and lot coverage. 2 variances for side yard setback, I should note, platform area and lot coverage. On file material from the applicant, as well as letters in support from 96, 97, 104 Dunblaine Avenue and 275, 277 JOICEY Avenue. We have our agent with us.
Yes, good afternoon, Mr. Chair, members of committee. Jonathan Weisel, architect, 36 Janesville Road, Thornhill.
All right, Mr. Weisel. Members, we have any questions? We require a presentation on this.
I just got a couple of questions, maybe. If you
Sure, Mr. Schwartz. Maybe we're dealing with a rear deck, so we can jump right to questions. I think it's reasonable.
Just so. Are we just dealing with the rear deck, or are we?
Yeah, so my understanding is our one property. We've got 98, and then we're going to deal with 100 next. But there are 2 properties under construction, and what they're requesting is a structure at the rear. The addition of a elevated platform at the rear would require 4 variances.
4 variances for the deck.
For that deck, yeah.
So I'm just.
Excuse me, Mr. Chair, 3 variances, I think, if you look at the notice, zoning notice. And Both of these houses are completed. I was not involved with the design or construction. I've been asked to help the two owners after the fact. There was a deck as part of the permit, and it's just now, they were built larger.
Sure. I'm just going to interject. So on the public notice for number 98, we do have 4 variances. I do note that on our next file, there are 3 variances, but staff, can we just pull up the public hearing? There we go. Already ahead of me. Sir, just if you don't mind, just take a quick peek at the public hearing notice. I just want to confirm everything's in order.
Okay, the 2 zoning notices that I have both show 3 notices, 3 variances, not 4. So I'm not sure what I'm trying to reconcile between the 2.
Yeah, there should be 2 public notices, one for 98 and another public notice for number 100. On the public notice, hearing notice for number 98, I do see 1 additional variance. Just take a moment to check that.
I'm okay with that. Just the 2 examiners notice that were part of the application only have 3, but if the notice has 4, then I accept that there's 4 variances for both properties. I accept that.
All right. Actually, a point of correction. There's 4 variances for number 98 and only 3 for number 100.
Okay.
On the public notice. Are you okay to proceed with that in mind, or if you'd like, we're getting late in the day, but I can stand this down, jump to 23, and then jump back to you to end if you just want to confirm that. But if you're okay to proceed on the public notices that are in our file, we can proceed right now.
Yes, I'm okay with that, Mr. Chair.
All right, let's proceed then. Okay, members, do we require a presentation?
I don't know if it's a presentation, but I just have a question about.
Yes, please, Mr. Schwartz.
I'm looking at this. We have neighbors in support. Are these the adjacent neighbors that are all supporting? Because I'm a little concerned about the privacy, even though it's already constructed, and maybe.
Yes, member of the committee, the neighbors on both sides and the 2 neighbors at the back are all in support. Those are the letters you have before you.
Yeah. So all neighbors, yeah. So it's hard for me to.
96 Dunblaine, 104 Dunblaine, which is really on the other side of Clyde, and then behind 277 JOICEY and 275 JOICEY. So the 4 neighbors directly impacted have all signed support letters.
Okay.
All right. Okay, sir. I don't think we have no more questions. All right. If it's all right with you, take this matter into committee. All right. Very well. Let's take this into committee now. Who would like to get us started? Mr. Mazziari, please.
Thank you, Mr. Chair. I just want to clarify one thing. There's a difference between number 100 and number 98. I think number 100, they don't have the side yard setback on one side. So it's 1.25. That's why they're just seeking 1 variance on one side, which is between the 2 properties. And the 98 that we are making decision about, they have 2 variances in regard with the side yard setback.
So just so I understand, so you're saying this the side yard setback, there only, so there's the side yard setbacks between the 2 properties, and then there's a side yard setback of the other neighbors who weren't part of these 2 properties.
That is correct.
Only on one side.
That is correct. But on the 100, number 100, there is no side yard setback variance because they are already more than 1.2 meters. And it's facing the street, so there's no neighbor.
So here, I'm going to turn this over to the architects because, like for me, the fact that the neighbors seem to have no objection, that carries some weight. Like I didn't lie. Otherwise, I would ask you architects about the privacy screen, and I'll leave it in your hands if you think we need a privacy screen. But whatever you say on this one. But I would have, in a non-architect's mind, I would have preferred a privacy screen. So you tell me.
Yeah, thanks for your suggestion. I am relieved that there is a consultation between the applicant and neighbor, and since I can see the support, letter of support, usually when we add privacy screen, it's adding more mass, so I wouldn't include that. So
sometimes, and it doesn't, approval without a privacy screen doesn't prohibit them from adding it on their own, right? If they, it can be done through landscaping, it can be done through the screen itself. Kind of two factors here. One is the fact, I think neighbor support is pretty critical, like privacy through these elevated platforms. The second part of it is generally I really don't like this sort of thing. Big elevated. To the agents, in support of the agent, I do recognize that this immediate around it, there's a lot of new builds, and there's a lot of these elevated platforms up in the air. They're not great, but it is. I would go so far to say that that type of form is immediate area. It's pretty common. So, you know, I'd be willing to support the application because of those two. I don't think if we had the neighbor support letters, I might be supportive of it, but the extent to consult with neighbors on both sides and at the rear, that shows some good faith.
It's already built. Neighbors support it. If it was here on a
maybe refuse, yeah.
I wouldn't be very happy about it. But
that's that.
I don't like it happen.
Consider it on its merits, but
oh yeah, built a built form. That should be like, yeah. If we don't like it, we like it. But the resident, I don't know if it's worth it. You are the. I will. You know, if you think there's a privacy screen, that if I was an architect,
you'd want that screen.
That privacy. That's all.
Yeah, I'll note too that the one of the lots is corner lot.
Yeah, number 100 is.
I do to Mr. Schwartz's comment about the privacy. With a lot of elevated platforms in the media, there are privacy.
To include that,
but
I don't have any issue. I don't have issue with the application itself, but I think that it makes a better application. I am fine to include that. I usually don't when there's no.
I might leave it to the neighbor, because if the neighbor doesn't want the privacy screen, and then let's say it's built, right, and neighbors all of a sudden there's a 6 foot tall or 1.5 meter high wall around it, and they say, well, the committee told us we had to do this. That's something I might leave to the neighbor to sort out.
Yeah, okay, fine. Neighbor like it.
It could be done with landscaping. I mean, personally, if I were in a situation, my property, some trees. Yeah, there's your answer. Landscaping is usually the best remedy for a.
This
poor
because I know you raise it all the time.
All right.
I think privacy screen would be good, but the neighbors say they're okay with it. It's already built. I don't know how much we want to get involved in it, but.
I proposed a privacy screen, and then I think Mr. Vizzelli said I'm okay without it. Let them sort it out. I usually, unless specific then from the neighbor, then I try not to, impose rulings that are restrictive, right, in nature. Gotta give 'em a
I mean, the
latitude.
neighbors, if
They-
somebody
they
did- if
certainly do.
They live in there.
Yes.
It's built.
Yeah.
If they want a privacy screen, they could have told the neighbor to build a privacy screen.
They could have.
Now, I would have asked my neighbor, can you put up a privacy screen? They didn't.
Showing the good faith that they've gone to the neighbors as well, and the neighbors actually went so far as to support. I'm confident that if there was some concern over privacy down the road, that they would be able to work that out together. They've established a type of relationship. All right.
It's in your hands, architects, whatever you say. I'll-
Okay, so based on our discussion, I put forward a motion to approve with no comment.
Okay, I'll second it.
Thank you, Mr. Schwartz. All in favor? That's unanimous. Application is approved. We're going to move right into item number 22, 100 Dunblaine Avenue. The purpose of the application is to construct a rear deck in to the detached being constructed. 3 variances this time. Side yard setback, rear platform area, and lot coverage on file material from the applicant, and 5 letters in support. We have our agent back. Mr. Wiesel.
Yes, Chair, yes, I'm here.
All right. If it's all right with you, I think we can take this right into committee.
Okay, thank you.
All right, let's move this into committee. Mr. Marziari has a motion.
Thank you, Mr. Chair. Similar applications, so I'd like to put forward a motion to approve no condition.
All right, do I have a seconder on that?
Yes.
Mr. Schwartz, all in favor? That's unanimous. That application is approved. Item number 23, last item of the day. 667 Rotting alter the existing 1-story detached dwelling by constructing a front covered porch and a 2-story south side addition, including an attached garage. Variances, rear yard landscaping, setback, and south side yard setback on file material from the applicant. Planning. We have our agent with us. We have our agent with us.
Hello, good afternoon, Chairman and committee members. My name is Eddie Perez. I'm at 537 Rogers Road. As you can see, we're adding addition and attached garage. We have the 3 variances. I was in touch with planning, and we're okay with 39.33% soft landscaping at the rear.
All right, thank you. That was my next question. So we do have modification to this application. That is going to be, sir, I believe variance number 1, if I'm not mistaken.
On the notice?
Yes, the public hearing notice. So we're going to be, staff, just for the record, the applicant on the public notice is requesting 30.2% soft landscaping in the rear yard. They're going to improve that. Mr. Perez, what was the number that you put forward?
It's the same as what the planning, we sent them drawings, it was 39.33.
39.33, and very good, staff are already on it. That is let me see, I can't see the, yeah, 39.33. That is in line with the recommendations noted in the staff report from community planning. Any questions?
I don't know if I got that late report.
It's on the screen.
It's on the screen? Okay.
Yeah, if you look right behind you, it's closer.
Let's see, well, let me look at mine.
They're recommending, staff are recommending modification to variance number 1 to improve the soft landscaping.
I don't know why I never got that. I can't find it, but the applicant's going to comply, right?
Yes, they're in line with the recommendations in community planning. Just for, so you know, Mr. Schwartz, the staff report is in the late package. It's one of the last items.
I was looking at the late pack. I don't see it, but
number
now I see
23, right at the end.
it. Really?
Yeah.
Hang on. Why don't I see it? I still can't find it, but I see it on the screen, and the applicant says they're going to comply with it. That's really all I need.
All right. Do we have any questions for our agent? All right, Mr. Perez, if it's all right with you, we can take this into committee.
Pardon me?
If it's all right with you, I can take this into committee.
Yeah, that's fine with me. Thank you very much.
All right, thank you.
Just,
All right.
sorry,
Before we do, Mr. Marziari.
Just a quick question from the applicant before we go to committee. I think the setback, variance number 3, 1.2, as you can see on the site plan, is happening for a portion of the building, not the whole thing. So if we approve this and tie it to the site plan, which is dated November 11th, do you have any issue with that?
No, the 1.2 is where the garage is on the side.
Yes.
It has to be attached to the garage. It's 1.2 meters away from the property line.
So you're okay to tie it to the site plan, right?
Yeah, we're okay with the site plan, no problem.
Yes, thank you, Mr. Marziari. That's a good recommendation. I also think I'm glad to see 1.2 meters there. It's about 4 feet. That's a good amount of space between the property line and the building. Just some brief comment because I want to get us on our way. I initially had a little bit of concern with the soft landscaping variance. I think in part the deficiency is from the fact that they had the garage at the rear, and then because the driveway comes right through the property, you have all this hardscaping. My initial thought, okay, if we're moving now, we're approving variances to accommodate a new garage at the front, then why couldn't we open up the landscaping at the rear? But I noticed that they have a drive door at the rear of their new garage, and they're still maintaining the existing garage. So I'm satisfied, especially given that they've had some discussion with community planning and they've improved that variance. I think the application is supportable. And pending no reservations from my colleagues, so I'd be happy to support second any motion.
I can start a motion and see.
Sure, please, yeah.
So yeah, as you mentioned, I think it's a supportable application. So I put forward a motion to approve this application as amended. So variance number 1 to be increased to 39.33%, and also variance 3 to be tied to the site plan, which is dated November 11th, 2025.
All right.
Yeah,
I'll allow Mr. Schwartz to second that. All right, all in favor? That's unanimous. That application, as amended, is approved with condition. Okay, the time is 5:27. Members, can I have a motion to adjourn, please? Mr. Schwartz, do I have a seconder for that motion? Mr. Marziari, all in favor? All right, we are adjourned. Thank you, members. Thank you, staff. And thank you, everybody, for your patience today. All right.